The letter arrived on a Tuesday afternoon, folded neatly in a certified envelope with my name printed in bold block letters. At first, I assumed it was another warning, maybe another so-called violation notice from the HOA. I had received plenty of those already, complaints about trash cans, driveway stains, even the angle of my porch light. But when I opened it and saw the words civil complaint and $50,000 in damages, my stomach dropped. The HOA wasn't just harassing me anymore. They were suing me. $50,000, according to them, for loss of property value, repeated non-compliance, and defiance of board authority. I read the pages twice, convinced there had to be some mistake. This wasn't some ongoing feud that spiraled out of control overnight. It started months earlier with a simple disagreement. I had replaced my mailbox after the old one rusted through, using a design that matched the neighborhood but wasn't purchased from the HOA's approved vendor. The board president didn't like that. Emails started coming in, increasingly aggressive, demanding I remove it. When I asked for the specific rule I was violating, they sent back vague language about uniform appearance. I asked again. No answer. Instead, fines began appearing on my account. I refused to pay fines that weren't tied to any written rule, and that's when things escalated. According to the lawsuit, my mailbox, and later my refusal to pay the fines, had caused the HOA financial harm, community disruption, and reputational damage. They claimed potential buyers were discouraged because of my non-compliant behavior. No photos. No buyer statements. No expert valuation. Just accusations stacked on top of assumptions. What stunned me most was the confidence in the document. The HOA's attorney wrote it like this was an open and shut case, like I should be scared into settling immediately. And judging by the $50,000 demand, intimidation was exactly the point. Friends told me to settle. It's cheaper than court, they said. Others warned me that HOAs almost always win. But something didn't sit right. I pulled out my HOA bylaws, the covenants, and every email I'd ever exchanged with the board. I spent nights reading state HOA statutes, learning what boards could legally enforce and what they couldn't. The more I read, the clearer it became, this lawsuit wasn't about damages. It was about punishment. They wanted to make an example out of me so no one else would question their authority. By the time the court date was set, the HOA board had already spread rumors that I was being taken to court for serious violations. Neighbors stopped waving. A few avoided eye contact altogether. The board president walked around like she'd already won, openly bragging that the HOA's lawyer was very expensive and that I was about to learn a lesson. What none of them seemed to realize was that lawsuits don't run on threats or attitudes. They run on facts. And the HOA, despite all their confidence, had overlooked one very basic requirement, something so fundamental that it would later stop the entire case cold. And they wouldn't realize that mistake until the judge finally looked up from the paperwork and asked a single, quiet question. Once the initial shock wore off, the lawsuit turned into something else entirely, a waiting game. After I filed my response denying every allegation, the case moved into discovery, the phase where both sides are legally required to exchange evidence. This was the moment the HOA's confidence started to crack. Their attorney sent over a thick packet of demands, requests for documents, photos, correspondence, anything that could show I'd knowingly violated the rules. I complied fully. I handed over emails, receipts, even photos of my old rusted mailbox and the replacement I installed. Meanwhile, I sent my own discovery requests back to them, asking for something very simple, the exact rule I had violated and proof of the damages they claimed. Weeks passed. Then more weeks. Their responses trickled in slowly, incomplete, and evasive. Instead of citing a specific bylaw, they kept repeating phrases like board discretion and general standards. When I asked for records showing a $50,000 loss, they sent meeting notes where board members speculated about possible decline in home values. No appraisals. No expert opinions. No actual numbers. Just opinions. One response even admitted that no home sales had fallen through because of my property. That single sentence alone felt like a crack in the foundation of their case. The deeper discovery went, the worse it looked for them. I requested enforcement records to see how similar issues were handled in the past. What came back was revealing. Other homeowners had replaced mailboxes, fences, and fixtures without using the HOA's preferred vendors. None of them were fined. None were sued. Some weren't even warned. The pattern was obvious. Enforcement only became aggressive after I challenged the board and asked for written proof. What the HOA called community standards looked a lot more like selective punishment. And selective enforcement, under state law, is a serious problem for any HOA trying to enforce rules in court. Behind the scenes, the HOA's attorney started changing tone. Emails that once sounded threatening became cautious. They asked if I'd be willing to resolve the matter amicably. One message even suggested dropping the damages claim if I would just pay the original fines and agree to comply going forward. That was the first time they backed off the $50,000 number. I refused. By then, it was clear this wasn't a misunderstanding, it was an abuse of power. They had filed a massive lawsuit without evidence, hoping I'd panic and fold. Now that the process forced them to show their cards, there was nothing there. As the court date approached, I noticed something else. The HOA kept missing deadlines. Documents arrived late. Some never arrived at all. When they did respond, they contradicted earlier statements. In one filing, they claimed the mailbox violated a long-standing rule. In another, they admitted the rule had never been formally adopted. That contradiction went straight into my notes. Judges notice inconsistencies, especially when they involve authority and procedure. HOAs are required to follow their own rules before enforcing them, and it was becoming painfully clear that this board hadn't. By the time discovery closed, the lawsuit no longer looked intimidating, it looked fragile. The HOA still talked big in public, but in the paperwork, their case was hollow. They had accusations without evidence, fines without rules, and damages without proof. All that remained was the hearing itself. And while the HOA was preparing speeches and arguments, they still hadn't addressed the one issue that mattered most. The one requirement they assumed no one would question. The one thing a judge could, and would, ask about the moment the case was called. And when that question came, everything they built this lawsuit on would collapse. The courtroom was smaller than I expected, quiet in that tense, official way that makes every sound feel louder than it should be. When the clerk called our case, the HOA's attorney stood up confidently, a thick binder tucked under his arm. 2 board members sat behind him, including the president, arms crossed, wearing the same smug expression I'd seen at meetings for months. They nodded at each other like this was already over. I took my seat at the other table, alone, with a thin folder and a legal pad. On paper, it looked like a mismatch. In reality, it was anything but. The judge entered, glanced at the docket, and immediately set the tone. This wasn't going to be a dramatic speech-filled trial. It was going to be about facts. The HOA's attorney began with a long explanation about protecting community standards and maintaining property values. He spoke confidently, almost theatrically, as if volume and certainty could replace evidence. He claimed my actions had undermined the neighborhood and forced the HOA to take necessary legal action. The number, $50,000, hung in the air like a threat, even though it had already shrunk quietly during discovery. When it was my turn, I kept it simple. I didn't argue emotion or intent. I pointed the judge to the documents. I explained that I'd asked repeatedly for the exact rule I violated and never received one. I showed where the HOA admitted no sales were affected, no valuations were done, and no formal rule existed at the time of the alleged violation. The judge listened without interrupting, flipping through the filings, occasionally marking a page with a sticky note. The HOA's attorney shifted slightly, glancing back at the board members as the silence stretched longer than expected. Then the judge began asking questions. Not dramatic ones. Precise ones. He asked the HOA's attorney to clarify which bylaw applied. The attorney cited a section about architectural harmony. The judge read it quietly, then asked where it mentioned mailboxes. The attorney tried to pivot, saying the board had interpretive authority. The judge raised an eyebrow. He asked whether that authority was documented in the governing documents. There was a pause. The attorney answered carefully, saying it was implied through practice. That answer didn't seem to land well. Next, the judge asked about enforcement. Had the HOA applied this standard uniformly? The attorney claimed they had. I handed up the records showing other homeowners who made similar changes without consequence. The judge studied them, then asked if the HOA disputed those records. The attorney hesitated, then said no. The board president leaned forward in her seat, her earlier confidence gone. The courtroom felt different now. Heavier. Like the momentum had shifted without anyone announcing it. As the questioning continued, it became clear the judge wasn't impressed by broad claims or authority-based arguments. He wanted structure, process, and proof. The HOA had none of the three. Every answer they gave seemed to raise another problem. No written rule, no consistent enforcement, no measurable damages. What was supposed to be a powerful lawsuit now sounded like a disagreement that should have never made it into a courtroom. Finally, the judge leaned back slightly and looked down at the case file again. He flipped to the front, then back to a specific page, tapping it once with his pen. The room went silent. The HOA's attorney straightened, clearly preparing for another argument. But instead of addressing the damages or the fines, the judge focused on something else entirely. Something so basic that no one on the HOA's side had bothered to prepare for it. He looked up, made eye contact with the attorney, and asked a single question that would stop the hearing cold. The judge's question wasn't loud or dramatic. He didn't raise his voice or lecture anyone. He simply looked at the HOA's attorney and asked, "Where is the written rule that authorizes the board to impose this penalty and seek damages in court?" The courtroom went completely still. The kind of silence where even breathing feels out of place. For the first time since this ordeal began, the HOA's attorney didn't respond immediately. He flipped through his binder, then another section, then paused as if the answer might suddenly appear if he stared long enough. He tried to explain that the board acted under its general enforcement authority and long-standing practice. The judge stopped him with a raised hand. "Practice," he said, "is not law. Authority must be written, adopted properly, and communicated to homeowners before penalties can be enforced." Then he asked a follow-up that hit even harder. "Can you show me when this rule was adopted and how the homeowner was notified?" The attorney glanced back at the board members. The president shook her head almost imperceptibly. There was no adoption date. No notice. No record. Just assumption. The judge turned a few pages in the bylaws and pointed to a highlighted section. He read aloud the requirement that any architectural or design standard must be approved by the membership and recorded before enforcement. Then he looked up and asked, "Did that happen here?" The attorney admitted it had not. He tried to argue that the board's intent was to preserve uniformity, but the judge was unmoved. "Intent," he explained, "does not replace procedure. HOAs are bound by the same basic rules of due process as any other governing body." What followed felt less like a debate and more like a lesson. The judge explained that without a valid written rule, the HOA had no legal basis to fine me, let alone sue for damages. Without proof of actual financial harm, the $50,000 claim was meaningless. And without consistent enforcement, the lawsuit bordered on arbitrary punishment. The board members shifted uncomfortably as each point landed. Their attorney stopped interrupting. He knew where this was going. Then came the words no HOA ever wants to hear. The judge said the case failed at the threshold level. Not because of a technicality, but because the HOA never had standing to bring it in the first place. There was nothing to enforce and nothing to recover. He didn't need to weigh evidence or hear witnesses. The lawsuit was fundamentally defective. He closed the file, looked directly at the HOA's attorney, and stated that the court would not entertain claims based on unwritten rules or speculative damages. The gavel didn't slam. It didn't need to. The judge simply announced that the case was dismissed in its entirety. No trial. No settlement. No second chance. The board president's face went pale. The confidence she'd carried into the courtroom evaporated in seconds. The HOA had spent months threatening me, trying to scare me into submission, and it had all unraveled because they skipped the most basic legal step of all. As I gathered my papers, the judge added one final remark. He reminded the HOA that courts are not tools for intimidation and that homeowners are not obligated to obey rules that do not legally exist. It was a warning, and everyone in the room knew it. The hearing was over, but the consequences for the HOA were just beginning. The hallway outside the courtroom was quieter than the room itself had been. The HOA's attorney walked out first, speaking in a low, tense voice to the board members. The president wouldn't make eye contact with anyone. Just an hour earlier, they'd walked in like this was a victory lap. Now they looked stunned, like they'd been sideswiped by something they never saw coming. I passed them without a word. There was nothing left to say. The lawsuit that was supposed to break me had collapsed in minutes. Within days, the neighborhood changed. The rumors the board had spread never came with a retraction, but their behavior said enough. The fines on my account quietly disappeared. The emails stopped. The violation notices stopped. Even the board president stopped walking her usual inspection routes. Neighbors who'd avoided me before started asking questions. Did they really sue you? Did you really win? When I told them the case had been dismissed because the rule didn't exist, the reactions were always the same: shock, followed by anger. People started wondering what else the HOA was enforcing without authority. The financial fallout hit the board harder than the embarrassment. Because the case was dismissed at the threshold level, the HOA had nothing to show for months of legal fees. Every dollar spent came from the association's budget, meaning from homeowners' dues. At the next meeting, residents demanded answers. How much did the lawsuit cost? Who approved it? Why was no vote taken? The board's responses were vague and defensive. Trust evaporated fast. The same authority they tried to flex in court was now being questioned by the people who gave it to them. Then came the resignations. First, one board member stepped down, citing personal reasons. A week later, another followed. The president held on the longest, but without allies, her power was gone. A special meeting was called to restructure the board, and for the first time, residents showed up in numbers. Motions were made. Rules were demanded in writing. Legal oversight was required before any future enforcement action. The HOA didn't just lose a lawsuit, they lost control of the narrative. As for me, life went back to normal in the simplest way possible. No more letters. No more threats. My mailbox stayed exactly where it was. The lesson spread quietly through the neighborhood. An HOA's power only exists on paper, and if it's not written, adopted, and enforced fairly, it doesn't exist at all. Courts don't care about intimidation or tradition. They care about rules and evidence. Looking back, the most ironic part wasn't that the judge dismissed the case. It was that the HOA never had to sue me in the first place. One honest conversation, one properly written rule, or one moment of restraint could have avoided everything. Instead, they chose force over process and paid for it in public, permanent fashion. They sued me for $50,000 to make an example out of me. Instead, the judge made an example out of them.